Philippa, what do you consider to be the most important best practice pointers when representing victims of trafficking and modern slavery?
I think it's very important to try and build up a rapport with the defendant slash victim. And being a defence practitioner, you're always presented with a victim in a hostile environment, whether it be in a police station or in the cells at court. And there is always a suspicion by the victim, who usually won't understand how our criminal justice system works, or that you're there to help them. So it's very important to try very quickly to build up the trust with that victim. And again, it's about asking the right questions and making them feel in a place where they are comfortable. It's also explaining to them in very simplistic terms the law, and explaining to them what an NRM referral is and what the victim identification process is. And many victims are foreign nationals who don't understand how our legal system works or the terminology. And trafficking and modern slavery are very big words, and in many cases victims do not identify as such, and it's something that you touched upon earlier. That self-identification is really important. Some of the other challenges is that we should be collaborating with other professionals. If they are a foreign national victim, have they given their account before? Have they given their trafficking background before? Has that been served as evidence? Can we obtain that? If you look at how many times a victim is asked to give their account in a criminal justice context or an appellant context, you know, it's to law enforcement, it's to the Home Office, it's to their criminal defence solicitor, it's to their immigration solicitor. So it's being really sensitive to, do I need to ask these questions? Has there been an account previously? Can I rely upon that account? What we also see is when we have lots of different people asking the same questions, usually it's with the use of an interpreter. We see that that's where we have inconsistencies because of the lack of good quality of interpreting or the misunderstanding of the questions. So it's very, a real sensitive approach in that instruction taking, the dialogue with other professionals involved in that person's case. So Ben, what are the challenges in prosecuting a case where a Section 45 is relied upon?
Well, I think you can look at that in three parts, really. First of all, investigation. Secondly, evidence. And thirdly, strategy. And in terms of investigation, first of all, the first thing to consider is the defendant's age. And it might not be a problem in many cases. Invariably, if you're dealing with somebody who's been brought up in the UK, it's not going to be an issue. Highly unlikely. But where you've got somebody who comes from a third country, then it may well be an issue. The CPS guidance on human trafficking, smuggling and slavery cases addresses the issue of age, and it provides there should be due inquiry into the age of the defendant where it remains in doubt. And where it remains in doubt after the inquiry has been held, the defendant must be treated as a child. And it's crucial that age is engaged with initially, because that will lead to a determination as to which of the two limbs of Section 45 applies, whether it's the adult limb, Section 45(1), or the child limb, Section 45(4). In terms of investigations, they need to be broad. Usually there's a focus on an offence to see whether or not somebody is prima facie guilty of an offence. It's got to be much more broad than that, and often investigators are caught out because they focus exclusively on the circumstance of the offence and not the broader picture. And with a Section 45 defence, you need to ensure the investigation is broader. In terms of evidence, you need to be thinking about different varieties of evidence to help you challenge a defendant who's raising a Section 45 defence. For example, most members of society in the UK have a social or electronic footprint. You need to be looking at NHS records, education, DWP, local authority records, and the absence of them, which of itself can tell a tale. Then in terms of strategy, you need to have judgment as to what to admit when, because of the way in which the burden of proof works. You can be caught out if your strategy is ill thought through. you.